Our program today features Prosecutor Fatou Bensouda, former Chief Prosecutor of the International Criminal Court. Prosecutor Bensouda hails from the Gambia and has been one of the most influential international jurists in the court's history. Prosecutor Bensouda, we're very honored and so privileged to have you join us today to recognize the United Nations International Day of Living Together in Peace. This day highlights reconciliation as the basis for peace and sustainable development. You have been an inspiration to many in your work for international justice and accountability. Prosecutor Bensouda will be in conversation with Parris, who will moderate the program, Ravi, President-elect of the Queens County Women's Bar Association and a partner at Vreeburg and Cattry law firm, Michael Eastridge, with Global Justice Advocates, and Maria Cortese, co-chair of the Women's Bar Association of the State of New York International Women's Rights Committee. Our moderator, Parris, is president of the Queens County Women's Bar Association and is a member of the Women's Bar Association of the State of New York International Women's Rights Committee, which she for several years co-chaired. She is an international law consultant and immigration attorney with Global Justice Advocates. In 2011, Faye served as a visiting professional with the ICC Office of the Prosecutor, where she advised the court on the legal premise of investigating gender-based crimes. I would like to thank the Queens County Women's Bar Association, New York Women's Bar Association, Brooklyn Women's Bar Association, and the Women's Bar Association of the State of New York for making this program a reality. My warmest welcome to all of you, and now I'll hand the program over to Faye Parris.
Thank you very, very much, Anne. Good evening, everyone, and thank you for joining us. Many thanks to all of our co-sponsors, and special thanks to UNA-NYC Executive Director Anne Nicole and composer and UNA-NYC Communications Associate Carlo Ladd. Nearly 20 years ago in Rome, world leaders affirmed the imperative of having a permanent court that would embody the highest standards of impartiality and hold accountable those most responsible for unspeakable acts against humanity. Decades prior, skeptics even considered the emergence of such a court to be impossible. Yet the glaring realities of World War II, former Yugoslavia, and Rwanda, along with insurmountable dedication, paved the way for the defining moment of the International Criminal Court. It is one exercise to read the Rome Statute and regulations of the court in abstract, and quite another to witness and partake in their evolutionary application to the first series of situations and cases before the International Criminal Court. Today I am joined by my esteemed colleagues Ravi, Michael Eastridge, and Maria Cortese. We are all thrilled and privileged to have a conversation with Prosecutor Fatou Bensouda, who served 18 years in the International Criminal Court, first as Deputy Prosecutor when she joined in 2004. Dr. Fatou Bensouda, or Prosecutor Bensouda, serves as prosecutor of the International Criminal Court from 2012 until 2021. She was elected by consensus in 2011 by the Assembly of States Parties to serve in this capacity. She was nominated and supported as the sole African candidate for election to the post by the African Union and is the first woman to serve as the prosecutor of the ICC. Her 9-year mandate as ICC prosecutor ended on June 15, 2021. Under her leadership, Prosecutor Bensouda has greatly reinforced the capacity of her office through a number of strategic and managerial initiatives and expanded her office's activities to cover roughly 14 investigations and countless active preliminary examinations in conflicts around the world. Through her work, she has strived to advance accountability for atrocity crimes, highlighting in particular the importance of addressing traditionally underreported crimes such as sexual and gender-based crimes, mass atrocities against affecting children, as well as the deliberate destruction of cultural heritage within the Rome Statute framework. Between 1987 and 2000, Prosecutor Bensouda held many positions in the Gambia, including the post of Solicitor General and Legal Secretary of the Republic and Attorney General and Minister of Justice of the Republic of the Gambia. At the UN International Criminal Tribunal for Rwanda, she first served as a legal advisor and trial attorney, and subsequently senior legal advisor and head of the Legal Advisory Unit. In 2004, she joined the ICC as the court's first deputy prosecutor and was previously a delegate of the Gambia during the meetings of the Preparatory Commission for the ICC. She is a recipient of numerous awards, including the distinguished ICJ International Jurist Award presented by the then President of India, P.D. Patil, the 2011 World Peace Through Law Award presented by the Whitney Harris World Law Institute, the American Society of International Law's Honorary Membership Award, and the 35th Peace Prize by the United Nations Association of Spain. In addition to receiving several honorary doctorates, Dr. Bensouda has been listed on 2 occasions by Time magazine as one of the 100 most influential people in the world, by the New African magazine as one of the most influential Africans, by Foreign Policy as one of the leading global thinkers, by Jeune Afrique as one of 50 African women who by their actions and initiatives in their respective roles advanced the African continent, and in 2020 by Forbes magazine as one of Africa's 50 most powerful women. In 2018, Prosecutor Bensouda received the Bled Strategic Forum's Distinguished Partner Award for the continuous commitment on her part and on the part of the ICC to international peace and justice. In the same year, she was invited and joined the eminent roster of international gender champions. Prior to the end of her mandate, Dr. Bensouda was awarded l'Ordre National du Lion du Sénégal by the President of Senegal for her dedicated service in the advancement of international criminal justice, and her native country, the Gambia, awarded her the country's highest civilian honor for her principled service as ICC prosecutor. At the end of her mandate in 2021, Prosecutor Bensouda was awarded the Outstanding Achievement Award by the International Law Association American Branch and the Sapienza Human Rights Award from Sapienza University, Rome, Italy. In April, she received the 2022 Prominent Women in International Law Award by the American Society of International Law. Dr. Bensouda and the office she led as ICC prosecutor was nominated for the 2021 Nobel Peace Prize in recognition of their accomplishments and work in advancing international criminal justice without fear or favor. Thank you all for joining us to celebrate her legacy. And now I thank you and welcome you, Prosecutor Bensouda.
Thank you very much. Thank you, Faye, for having me, and thank you so much for that introduction. I'm pleased to be here and to be able to share this conversation with all of you.
Thank you so much. Thank you. Thank you. And it is our pleasure indeed. So I would like to get started just to give people a little bit of background. At what point in your career life did you realize that you wanted to be a prosecutor, and why?
I wouldn't say that I wanted to be a prosecutor as such, but what I wanted to be was to have something to do with justice. I felt at a very early age, in fact, even in my high school, I can say, I felt that I needed to contribute, that I should place myself in a position where I would contribute to ensure that justice is done, especially for the victims. And by victims, I would say, especially those who would not easily have access to justice, whether it is because they couldn't afford it, or just because at that time, maybe they were not offered the protective embrace of the law. So for me, from a very early age, before even I left high school, I was thinking that I should be able to do something. Of course, it was not very clear to me at the time, but I wanted to serve, and I wanted to ensure that when it comes to justice, especially for women, that I was there and I could make my humble contribution. So really it was a matter of justice, seeing that justice is done. And it was something very innate in me. Perhaps it was the background that I was confronted with. I was in the law courts working before I went to study abroad. And I also saw that really more needed to be done, and more especially from us women, who I felt we were relating more to what was going on in the courts.
Thank you so much, and I'm very. All of us we have a great debt to you for making that choice. So. Yeah. My next question, I just want to give a little background for our audience. During your tenure as chief prosecutor, in all of your strategic plans, in fact, and in particular, the office's policy paper on sexual and gender-based crimes and policy on children, you clearly define the office's key agenda to make the investigation of gender-based crimes a priority. And in this process, the office was very transparent and invited NGOs to provide comment on the policies. And I remember that period. To summarize, the policy was established to ensure the effective investigation and prosecution of sexual and gender-based crimes from preliminary examination through appeal, and also to contribute to the ongoing development of international jurisprudence in this regard with respect to gender-based crimes and sexual crimes. And indeed, today we celebrate your legacy at the ICC in this regard. So looking back, one might surmise that lessons learned from the Lubanga case, that's during the time that you were deputy prosecutor, but it's the first prosecution before the ICC. I believe that set the stage for many questions about how the office of the prosecutor is to effectively investigate sexual and gender-based crimes. And as we know, in the Lubanga case, it arose out of the investigation into the situation in the DRC, Democratic Republic of the Congo. He was the commander-in-chief of the Patriotic Forces for the Liberation of Congo, and he was charged with enlistment and conscription of child soldiers. And while charges for gender-based crimes were absent, it was clear from testimony from actors in the trial that rape and other forms of sexual violence were a component of the conscription process. And also the trial chamber did rule to modify the legal characterization of the facts to include inhuman and cruel treatment and sexual slavery, but this was overturned on appeal. So my question to you now, looking back at that very first case, what were, three questions I have for you. What were your impression of events surrounding the Lubanga case within the office, or even with respect to the media? What were some of the issues and challenges that the prosecutor faced, the office of the prosecutor faced in the Lubanga case? And what are some of the lessons learned, please?
Thank you very much for that question, Faye. The Lubanga case, I remember I was not yet prosecutor, but of course I was the deputy prosecutor and directly also in charge of the case. And you have mentioned most of the challenges or how the case went, and the fact that we only charged, or we charged for conscription and enlistment of children below the age of 15. And I can tell you today that was a very deliberate charging that we adopted at the time. We saw that the enlistment and conscription of children was a very, very serious offense under the Rome Statute. It is affecting a whole generation. Children as young as 8 years or even younger were kidnapped and taken to camps and then turned into killing machines. And they grew up, and that is all that they know. And as far as I knew, this crime was not really receiving a lot of attention. Even though it was prevalent at the time, it wasn't receiving attention. And my office at the time, of course, under the leadership of my predecessor, was determined that we were going to highlight this crime, that we were going to bring it to the fore so that the whole world pays attention to this crime, to this generation of people whose life become ultimately completely destroyed. And for something that they have no idea even of what was happening, what was going on. So this was a deliberate charging in the end. And of course, we got heavily criticized. You talked about the media. The office was heavily criticized that this was sort of minimizing the effect of this crime, that there were blood crimes, as they call it, murders and tortures and sexual and gender-based crimes and all of that. When the office should have charged for that, we only came in for conscription and enlistment of children. And you have mentioned it in your question, Faye. This crime, in fact, envelopes all these other crimes, apart from the fact that we were charging enlistment, the fact that during their life in the camps, during the time that they serve as child soldiers, they commit murders, or murders are committed on them. They are made to witness horrific crimes. Sexual and gender-based crimes happens during this time. They are turned into sex slaves. They become spies. They are cooks. They are emissaries. All sorts of crimes happen during the time that they are enlisted and conscripted. And definitely we thought that it was time for the world to really look at this phenomenon that was happening and destroying a whole generation. So this is why we charged for this crime. And I believe at the end of the day, when Lubanga was convicted, and when really, I believe the world started noticing about this crime, I believe the office was completely vindicated for that case.
Oh, no, I'm sorry, I didn't mean to cut you. Please continue.
No, please.
I was going to say, I recall that because I think, people didn't realize, I mean, what you did is you normalized the fact that sexual violence is a normal part of the conscription process.
Sure. Yeah. In fact, yeah, that's what we did, because in the evidence that was led, we just showed, we laid bare the life of a child soldier, whether it's a girl child soldier or it is a male child soldier. We just laid it bare, and we're able to expose everything that happens to these poor children. And of course, Lubanga was convicted, and on appeal also it was confirmed. But it was a case that I was particularly interested in signaling to the world that this is something that is happening, and we cannot take it lightly. We cannot take it lightly. We need it as an international community, as a court, and as a responsible group concerned about these horrible crimes under the Rome Statute, that it was important that we bring it to the fore.
Thank you so much, and we are very grateful to the office for that. So there were many wins, in fact. The Ntaganda case presented a big win for the Office of the Prosecutor, and it reveals the office's multifaceted approach for investigating and prosecuting sexual violence and armed conflict. In fact, this also arose out of the conflict in the DRC. He was the commander of the PLLC, and we know that the initial arrest was issued in August of 2006. That particular arrest warrant didn't reference sexual and gender-based crimes, but later on in May of 2012, the office filed an application, and the warrant did add 9 charges, including rape and sexual slavery as war crimes. And then later on, again, in January of 2014, when he surrendered to the court, additional sex violence charges for the war crimes of rape and sexual slavery were added. So, that is a very significant case, and I would like, if you can, to, explain what the significance of this case is. And also, I'd be curious to know how NGOs were involved in leading to, the warrants of arrest and getting the other additional information pertaining to sexual violence, please.
That's right, Faye. Perhaps what I did not mention in my previous answer was the lessons that we took away from the Lubanga case, especially especially with respect to sexual and gender-based crimes. This became a very important focus for the office, and as early as 2014. I think just 2 years into my serving as prosecutor of the ICC, I had already set up this big project in which I wanted to launch a policy on sexual and gender-based crimes. And you mentioned it was a policy with very wide consultations. And in the end, I think it's a very good document that we have now. And I ensured that not only we had the sexual and gender-based policy, but also we had training of staff on it. I think that was the most important part, the implementation of the policy itself. This was critical for me, and we have had several experts come to the office and work with the staff or train the staff in terms of investigating and prosecuting sexual and gender-based crimes. So coming to this case of Ntaganda. Ntaganda, of course, we had already charged Ntaganda, and the warrant was outstanding. It was there. Even though we had not closed the case, but it was more or less there. But one thing that I wanted to also clarify was that we continued investigations, maybe not at a very high speed, because there are other cases that also needed to be investigated. But we were still looking at what we could do or more charges to bring. So when he surrendered to the ICC, he surrendered in Kigali, and of course at the American Embassy. And this probably is later something that we can talk about, because he's surrendering at the embassy of a state that is not a party to the Rome Statute. And this is happening in Kigali, Rwanda, which also not a state party to the Rome Statute, of course, with no obligations to cooperate with the office as such. So we needed to find ways in which we could seek their assistance and their cooperation for Katanga to be Ntaganda to be brought into the office. And finally, we were able to achieve this. But one particular thing that I probably should mention about the Bosco Ntaganda case is the charges, the fact that we were able to push the envelope, in the sense that we charged Ntaganda with crimes committed against the children or the victims in his own camp. If you look at the previous to that, if you look at the state of the law, is that the charges will only be directed, or the charges were concerned the victims in the opposing camp. But we said, of course, these people also within the own camp also deserved to be protected. And the state of the law was that they were not protected with the way the charging was done. So we were able to bring this. Unfortunately, we had the charges confirmed, and we were also able to get him convicted on those charges, and even on appeal. So this is, I believe, it's a major contribution that the Office of the Prosecutor under my tenure was able to make to international criminal law and justice.
And you know what, and I think, and believe it, correct me if I'm wrong, thank you, Prosecutor, he was convicted of 18 counts, is that correct, about 18?
Yeah.
So that's a huge win. That's a huge win.
Indeed.
Yeah. So, well, you know, another interesting question, and it's something that I think a lot of people want to know. It has to do with command responsibility, or when someone's a senior official in charge. So particularly with respect to the case of Katanga and Bemba, as you know, Jaman Katanga was convicted for the war crimes of directing an attack against a civilian population, pillaging, destruction of property, as well as murder as a war crime and crime against humanity. However, he was acquitted, if I'm not mistaken, of all sexual and gender-based crimes, and the war crime of using child soldiers. And while the trial chamber determined that combatants within the militia group that he led committed rape and sexual slavery, it found that there was not enough evidence to show that these crimes fell within the common purpose of the group, sufficient to establish his culpability or his liability. And then in the Bemba case, we see also the first conviction of gender-based crimes on the grounds of command responsibility overturned. But my understanding is, notwithstanding these, what one would call a setback, it really was an opportunity for further development of law as it relates to gender-based crimes and prosecution. So I would ask if you could sort of elaborate upon what the challenges were in both the Katanga and Bemba cases, and in your opinion, what implications do they have with respect to the future prosecutions of commanders?
As you rightly says, Faye, we always find, or usually you find, that commanders are not in the field. They usually give commands and others execute them. But if you look at the Rome Statute as it stands, commanders are responsible for crimes as long as you're able to link them. So it is not an excuse, even for those who commit the crimes, to say that I only did it because my commander asked me to do it. I was not doing it on my own. Neither can the commander claim their position as being commanders and therefore could not be held responsible for this crime. So it is there. It is in the Rome Statute, and it is very clear. So in both the Katanga and the Bemba cases, we were charging based on these grounds, the fact that these are Rome Statute crimes, and we felt we had the evidence, or we saw we had the evidence to be able to charge them as commanders before the court. Particularly with respect to the Bemba case, this is one case that was, I think, particularly very hard on the office of the prosecutor. I think unnecessarily. This was a case that was brought, first we requested for arrest warrants to issue based on charges and Bemba as a commander. And 3 judges decided that these arrest warrants, there is basis for the arrest warrant to issue. Bemba was brought before the court, was eventually arrested and brought before the court. And the charges that we brought against him were confirmed by 3 judges at the pretrial chamber. 3 judges on this command charge of commission by a commander. It went to trial, and the prosecution was found to have proved its case beyond reasonable doubt by 3 judges, and Bemba was convicted. It went on appeal, and of course, that is when the case was overturned. And until today, I think even the issue of command responsibility is in a state of flux. Because at that time, if you remember, 2 judges agreed, and 2 judges dissented with, and then 1 judge also agreed, but on different grounds. So how should people charge now? Because there is really no clarity even at that level. But I do hope that, and this was always my aim, that the office of the prosecutor would try as much as possible to make sure that the law is clear. And that by bringing charges, maybe in a different form perhaps, but bringing charges to demonstrate that command responsibility is within the Rome Statute, and that a person who commands his troops to commit certain crimes, and that there is linkage between those crimes and the commander himself, he could be found guilty. He should be found guilty of those crimes.
Thank you so much. And I think also, it is an opportunity for further development, and even as the jurisprudence is developed, that's also going to be very informative. So there are many wins, like within the Ongun case, as well as with Darfur. And I want to, there's so many cases. I want to focus on Darfur because it's current and it's something that we really are excited about. So with respect to the Darfur situation, as we all know, the Office of the Prosecutor has faced many, many charges. In a prior statement, you even reference a milestone in the international criminal justice, and this is the surrender and transfer of Ali Muhammad Ali, also known as Ali Kushayb. And he's the alleged leader of the Janjaweed militia, to the custody of the ICC. And today we're witnessing the first ICC trial on Darfur crimes, with him facing trial. And, we know that this has been going on for a long, long time. You recall that when you were chief prosecutor in your office, the OTP's team, the prosecutor's team, negotiated his surrender. And this is a very interesting time to the ICC. You were able to move this case forward. And I just want to read a quote when you were thanking and congratulating your office, because I have questions about that statement. So in a recent statement, you express your appreciation to your dedicated team, along with colleagues and from the registry. And this is what you mentioned. You say their tireless efforts in the exercise of our respective independent mandates contributed to today's development and successful transfer to the court. Today's outcome was achieved, notwithstanding the complexities of the operation, not least in the midst of added complications presented while operating in the COVID-19 pandemic context. So I am very curious, particularly in this situation, particularly given all that we know about trying to have, for example, al-Bashir come and other leaders come to face trial. Can you describe some of the issues that prevailed in the Darfur situation, and also elaborate upon the significance of the Kushayb trial, please?
The Darfur case, if you recall, the situation was referred to the ICC Office of the Prosecutor by the UN Security Council. And of course, it is, I always like to emphasize that it is not always because the UN Security Council would refer a case that the ICC Office of the Prosecutor would certainly go ahead and intervene in that situation. At least this was my position as prosecutor. I always felt that we needed to subject the particular situation, like any other situation, by looking into it, the preliminary examination, however short, but look at the case to see that whether ICC should really intervene, the gravity of whether ICC crimes have been committed, whether there is temporal jurisdiction, and the gravity of the crimes to warrant the intervention of the ICC. So Darfur, the situation in Darfur was also subjected to this examination. And when the criteria was met, the office decided to go ahead and investigate in that situation. And Darfur was particularly challenging because as soon as the office decided to open investigations into the situation, Sudan shut up. They shut down. They said, no investigations. We are not allowing ICC staff on our territory. So complete shutdown that we were not. So we had to investigate Darfur without going to Darfur. And so you can imagine the challenges, because even when you have a free hand to go in and out of a particular situation, there are many challenges in investigating these crimes. Now to have that country say that, no, we're not going to allow ICC to come in was particularly challenging. And of course, it was also at a time when there was this accusation all over the place that ICC is targeting African leaders. There was this strong propaganda against the ICC, which initially we thought that this is not serious. But eventually, of course, it was able to gain ground, and many people, many ideas were turned on ICC that it is a court built for Africa and it's targeting Africans. So we had challenges in Darfur, and we had to do a lot of work with African leaders, with others who would assist the court in getting Bashir, and eventually the warrants were issued in getting him over to the ICC. In fact, even with respect to those who provide the funds for the office of the prosecutor, year in, year out, I had to justify before the CBF why we still needed to have the Darfur case and why there is great expectations for justice, and that we, the ICC, were the only hope for justice to be brought to the Darfur people. And so I just continued. I refused to surrender. I thought that there was at least a duty and a responsibility to push for this case to happen. But as you remember, Bashir was also charged with other people, and Ali Khoshaib was one of them. There is also others who were part of the Darfur case, but when we got the opportunity to get Ali Khoshaib to come, we were able to arrange that, and supported very much by registry. And finally, we got Ali Khoshaib to the Hague. And in fact, I did make the initial appearance in that case. And I am very pleased that today the trial is ongoing. And again, I will say that this was really due to the efforts of the Office of the Prosecutor under my tenure, that today we have this case before the ICC. And of course, I'm hoping that eventually justice will be done.
And I thank you so much, and I think it's a big tribute to all of the victims who have waited for so long. It speaks volumes to the measure and importance of the work that you have done. So I thank you for engaging me during this first segment of our conversation, and now I have the pleasure of handing you over to the next interlocutor, Ravi Cattry. And I just want to give you a little bit of background about Ravi. Ravi Cattry is a partner of Vreeburg and Cattry, PLLC, practicing primarily matrimonial and family law. She is also an active member of the legal community, which she now serves as president-elect of the Queens County Women's Bar Association, co-chair of the Women's Bar Association of the State of New York Equal Opportunity in the Profession Committee, and vice chair of the Family Law Committee of the Queens County Bar Association. I thank you very much and welcome, and hand the mic over to Ravi, please.
Thank you so much for that incredible introduction, Faye. And your part of the interview has been so incredibly insightful. And thank you for being with us today, Prosecutor Bensouda. And as Faye mentioned, I primarily practice family law, and oftentimes I'm required to work with children as witnesses, such as in the context of domestic violence cases. When addressing child witnesses and securing their adequate protection, what are some of the Office of the Prosecutor's best practices, and how did these practices result in the children being given a sense of agency? And how do you ensure that the children witnesses that they feel safe to come forward?
Thank you very much, Ravi. That's a very good question also. After I was done with the sexual and gender-based crimes policy, I also realized that in these conflicts, women and children really bear the brunt of the conflict. I mean, I often used to say that it's as if the war is fought on women's bodies, but also children are very much implicated. So my next policy that I targeted was the children's policy. And again, I went through these very huge consultations. And I was assisted by a very able attorney and practitioner and lecturer, and my special advisor, Diane Ammon, on this trying to get the children's policy. And what I wanted to, in fact, how I named the policy was to say children in and affected by armed conflict. And I wanted to examine, first of all, how children are affected. And you will realize that they're affected in many ways. If they are not the direct victims, their parents are victims, and maybe they are left as orphans, or their schools are destroyed and they can no longer go to school, or the community is so turbulent that they themselves could not even have a peaceful life. They could not have a normal life as children. So I thought that, again, this was an area we needed to look at into very, very closely. And even when we were looking at it, we even made sure that the children were part of getting the information we needed. We listened to the children. We consulted with them and we listened to them. And this was also part of eventually when the policy on how to approach them, how to talk to them, how to make sure that if they needed a guardian next to them, they will have it. For instance, during the trial, we have to ensure that when they come into the courtroom, it is a safe and a secure place for them to be. We had an experience, unfortunately, at the first witness we had in the Lubanga case, in which this witness was made to see Lubanga in court. And I think that definitely affected the performance of that witness. In the end, we had to adjourn the case and to start again. And we realized that this was a mistake, that should not have happened. So all of this now, if you look at the children's policy, we have tried to embody it in the policy. We've tried to show how to approach these children. We've tried to show how to make them comfortable. We've tried to show that, for instance, we have a children's unit. We had a children, at least under my term, we had a children's unit, gender and children's unit that just basically dealt with these things. And within the gender and children's unit, we have psychosocial experts, trained psychosocial experts who would also look at the way we approach victims, especially women and children, and how to talk to them and how to make them feel comfortable from the time that we approach them to the time they come to court and even afterwards. I think this was critical that we did that.
Thank you so much. Changing tactics a little, I was just wondering, what are some of the greatest challenges that you've encountered during your term as chief prosecutor? And can you explain how those challenges reflect the misunderstandings of the role of the ICC Office of the Prosecutor and its functions, along with what the state's obligations are under the Rome Statute?
I mean, as a prosecutor of the ICC during my term, I was definitely confronted with my team with several challenges. One of those is, of course, the perception that was created that the ICC is a court that is set up for everything else other than to do the work that is very clear under the Rome Statute. We were accused of being a political court. We were accused of targeting a particular region in the world, and that is the African region. We were accused of doing victor's justice and all sorts of things. And this, unfortunately, had an impact on the cooperation that we also would need. Because as you know, ICC was set up as a court in which we will, of course, do our legal, our judicial work, but we needed the states parties to cooperate and assist the court in doing the investigations and prosecutions of those cases. So cooperation also became a huge problem. And some would not cooperate. Some would deliberately avoid to cooperate with the court. For instance, when we wanted people arrested, we have seen several times where fugitives of the court would visit states parties to the Rome Statute who had obligations under the Rome Statute by being signatories or states that have ratified the Rome Statute to arrest and surrender to the ICC. But we've had several examples in which this was not done. So those are major challenges that the office faced, as well as the budget of the office. I mean, you're dealing with cases which are huge, big cases. And as time went on, we realized that we had to deal with several cases at the same time. But the budget of the court would hardly move. The budget of the OTP would hardly move. And this became a problem for us to be able to turn and look at all the cases that we were supposed to look at. And of course, the perception this creates is that there were double standards, for instance, that we would do one case and wouldn't do another, not knowing that we did not, because we simply did not have the resources to be able to do that. So these are just some of the few challenges that we were confronted with as an office. I don't think that it will go away completely, but at least in the latest developments, I think that perhaps some of the budget problems will be solved, or at least minimized.
And what were some of the unique challenges that you personally faced as the first female chief ICC prosecutor?
You know, the problem that women that we continue to have, that we continue to face, and sometimes even in the most progressive societies, you have that. There's always this thinking or feeling, even if they do not say it, that first and foremost, she's a woman. You know, she's a woman, probably she would not be able to do it as well as a man would, or perhaps not even be able to do it in the first instance. And I always used to say that they forget that I was very well qualified and very well equipped to be elected as prosecutor of the ICC. In fact, my election was by consensus. There were no states dissenting that I should not be elected as prosecutor. And this was a strong message, I believe, that was sent. But notwithstanding, in the practical day-to-day life, you find those ones. Sometimes it's very subtle. And if you're not even careful, you may miss it. But sometimes it's there. But I have always said that I hardly give consideration to my gender. I'm not saying that I'm not happy being a woman. I am, of course. But this was not what I needed to do what I was supposed to do. That's what I mean. What I needed was to be fully equipped, well equipped, to be able to perform the functions that was required of me. The fact that I was a woman should not in any way or term make me lesser of a prosecutor than a man.
And did you find certain of these challenges also arose when you were dealing with heads of state?
Well, I have to say though that I have generally received a lot of support from African heads of state, even though they have taken a very strong position against the court. And if you remember, I think in 2015 or 16, there was this threat of mass withdrawal from the court by Africans. But we took it upon ourselves to really reach out to the African leaders. I made several visits. I spoke to many of them. Many heads of state, they received me very well, and we were able to speak. And as they would normally call me, my sister, they would say. But I have to say that it is really largely due to their support, especially some of them. I just do not want to go into names, but they were able to reverse this position, this very strong, or help to reverse this very strong position that Africans had taken, or African leaders had taken, to do a mass withdrawal from the ICC. So I would be honest and say that I have definitely received good support from African heads of state. If you also recall, at the end of my mandate, which Faye has made reference to, Senegal being the first state party to the Rome Statute, the head of state of Senegal found it fitting to award me with the National Order for Merit when I completed my mandate. I think that was very encouraging for him to do.
And well deserved.
Thank you.
Many people question or are unable to fully articulate the relationship between the ICC and the United Nations. How would you describe that relationship?
Well, the United Nations, especially the United Nations Security Council, as you know, is a political body with responsibility for security around the world. But also, in the Rome Statute, the UN Security Council has been given powers of referral and deferral to the ICC. So for example, instead of creating a new court, the UN Security Council can refer situations to the ICC to investigate and prosecute. Or when the UN Security Council is engaged in perhaps peaceful negotiations to sort out a particular situation, they can also ask, if ICC was investigating in that situation, they can also ask the ICC to stop so that they could continue with this. But you know, I see the relationship, I see the two bodies that they should be able, I mean, normally they should complement one another. They should complement one another because ultimately, if there is accountability for those crimes and the ICC is able to bring peace and security to a particular situation, I think the credit will also be for the UN Security Council. So this is why I believe we should continue to work together. Perhaps the difficult situation with it is that the UN Security Council is a political body. And of course, there are members of the council or who perhaps would not agree with the intervention of the ICC, for instance. Or even when a referral is to be made by UN Security Council, which they can do under the Rome Statute, that this would not be something that all members will agree that this referral be made to the ICC. We have had and seen several examples of that already. So I think we need to, what I worked on before leaving the ICC was to find a way in which we can improve on the relationship that the ICC has with the UN Security Council, how we can maximize the efforts that both of us were making to ensure that peace and security returns to particular situation. And that we should be able to do this by talking more, by being in contact, by looking at even thematic issues and be able to discuss them and see how, as bodies with different mandates, of course, different mandates, will be able to address them. This is particularly important.
Thank you so much. Now I'm going to turn it over to our next presenter, Mike Eastridge. Mike is an international human rights and immigration attorney with Global Justice Advocates and is the founder of Peace Tending, a nonprofit organization dedicated to empowering religious leaders in implementing transitional justice initiatives in post-conflict states. Mike?
Thank you, Ravi, and thank you for your questions, drawing out some important insights. And to you, Prosecutor Bensouda, we're so grateful for you taking the time today to meet with us, give us a chance to honor your legacy and your commitment to the international community. So thank you so much for being with us.
Thank you.
What I'd like to do is maybe broaden the perspective of international justice and accountability. And maybe you can help us get a sense of the role of the ICC in this, maybe this bigger context. So let me begin with something that you had mentioned in the previous questions about some of the challenges that you have as the prosecutor in the office of the prosecutor, because the cases that you bring are enormously important, require lots of resources, time and effort, and navigating a lot of political landmines to do that. So it stands to reason that whenever there is someone who is potentially guilty of committing war crimes, atrocities, international crimes that you would prosecute, that you can't prosecute everyone. I mean, there's just no way that everyone who's culpable of committing war crimes or crimes against humanity can be brought to The Hague for trial. So, so in this broader sense of, so how do we bring about accountability and international justice in situations? I'd like for you to maybe share your perspective a little bit on the role of transitional justice or restorative justice practices that might complement the work of the ICC in those areas. So for example, I know under the concept of where you're allowing the local states to try cases against for crimes against humanity, that sort of thing. Complementarianism. There are states sometimes who, after emerging from conflict, don't have the capacity to try people, perpetrators, who may be guilty of these crimes. Perhaps it's because the judicial system itself has not been able to survive the conflict. Sometimes in tyrannical states or autocratic societies, you have courts and judicial systems who at best are complicit in some of the human rights violations, and in some cases, they may actually be instruments of the state to perpetuate human rights abuses. So in the absence of a situation state where the International Criminal Court might be focused on individuals, your mandate to prosecute those who bear the greatest responsibility for the greatest harm,
That's right.
you don't always have a complementary justice system that's able to prosecute others. So compounding that in some cases is the fact that the harm is collective harm. So entire communities or social structures or institutions may be the victims in a conflict state. So could you share with us a little bit of your perspective on the role of the International Criminal Court in this broader context of other accountability mechanisms, transitional justice mechanisms, such as a Truth and Reconciliation Commission or Palava huts? How do those types of mechanisms, how can they complement the work of the International Criminal Court?
Thank you, Michael, for that. And I just want to go back to 1998 in Rome, when the International Criminal Court was established. And this was over 100 states, almost the entire membership of the United Nations gathered together. And that was the final decision made, that an International Criminal Court will be established. And of course, after the ratification of 60 members, 60 states parties, the court will come into being. And in 2002, this court came into existence. And if you look at it by standard of international treaties, it was perhaps one of the fastest that came into existence. And this for me demonstrates the fact that there was really this yearning to have an International Criminal Court that will hold people accountable for these very serious crimes of war crimes, crimes against humanity, and genocide. And until recently, the crime of aggression. But this was the indication and the enthusiasm that we needed to have this court. But when the court was established, Michael, I don't need to tell you this, the court was not made as one of a last resort. The court was established as a court of it was a court of last resort and not a court of first instance. And that meant that states were still not deprived of their primary obligation and responsibility to investigate and prosecute. It is only when they are unable or unwilling. You gave an example, for instance, there is a total breakdown in the domestic judicial system that signals inability. But there could also be the problem of lacking of political will. So unable or unwilling. And this is when the ICC, once it has jurisdiction, it's a state party or there has been a referral, that it can step in and investigate. So unlike the ad hoc tribunals, if you remember with the ad hoc tribunals will claim primacy over these crimes. And they would actually tell the state to sit back whilst they would do it themselves. But this was not the case with the ICC. The ICC, it was said and it was agreed that once the ICC steps in, that means that nobody was investigating and nobody was prosecuting, there was inability or there was a lack of political will. So this is still giving a chance to the domestic jurisdiction to take over this case, the situation and investigate it. But what we have seen over the years, there is really much of this lack of political will. And also there is a lot of this lack of ability to investigate and prosecute. Because if you see in most of the cases that have been referred to the court, there is followed a declaration by that state saying that we are not in a position to investigate or prosecute. In the DRC, we have had that. In Cote d'Ivoire, we have had that. In other situations, we have had this particular state. But then, so this is really the role of the ICC as an accountability institution, a body that will investigate and prosecute very serious crimes that we have agreed shock the conscience of humanity. And of course, the difference with all this transitionary justice is the fact that with ICC, it's about individual criminal responsibility. And this is what we do. ICC investigates and ICC prosecutes. That is the role. It's an accountability role. Whereas other forms of justice, of course, there can be negotiations for peace. There can be situations in which NGOs or other states are involved in trying to settle the dispute or the conflict without necessarily finding any particular person guilty of any crime. There can be situations where there is reconciliation. There are truth commissions. So all this is really not ICC's role. But what we have done, at least under my tenure, and I very well know under my predecessor's tenure, what we have tried to do is to be sensitive to also what they're doing, the work that they're doing, to be sensitive to that. And sometimes you may wish to take certain actions, but if you see that the action will aggravate the situation and not help it, perhaps you can time it. Perhaps you can time that particular action to see whether a good outcome could come out of it before you really step in. And instead of helping the situation, you probably make it worse. So those are considerations that one could take. But definitely the mandates are different. They have what they have to do, and to see how they negotiate for or reconciliate. But ICC's role is individual criminal responsibility, and this is really how I saw my role. That it was for accountability, and I just stuck to that. But it didn't mean also that there was no kind of dialogue or discussions with those who are doing other things than what I was doing.
Yeah. Thank you for that insight, and that's really helpful. So let me follow up just a little bit more on that. So do you see a challenge, for example, when you have a conflict state and know that your office is investigating, you've got investigators on the ground. In terms of the timing that you just mentioned, is there the risk of complicating investigations if there are other processes that are taking place at the same time? I mean, is there maybe a sequential way that some of these other judicial mechanisms could coordinate? I mean, is there a formal coordination with your investigators to make sure that there's not, conflict in that, in those unique roles?
Well, investigations can be quite complex. And sometimes you find all these challenges. I remember in one of or two of our investigations in which we had quite a pushback from those negotiating for peace that ICC should just back off and let them do their work. And ICC is, and we have also had accused persons or suspects who had made it a condition that they would come out or they would come forward if ICC were to withdraw the warrants that had already been issued against them. So you will have these challenges. They will be there. But what I've always advocated for was that justice, accountability, negotiating for peace, peace and justice should not be mutually exclusive. In fact, they can be reinforcing. And really, these two groups cannot sequence or decide to exclude one another in what we were doing. It really needed at least talking to one another and seeing what could be done. At the end of the day, what I have always said is that what was important was that peace, security, and justice should come back to that community. And even though we have our different mandates and independent mandates, there could be a way in which we can mutually reinforce one another. I'll give you an example of like the Uganda situation. When the warrants were issued, I remember my predecessor coming out to say that the warrants are issued, but at the same time, I remember the Uganda government was also giving out amnesties. So my predecessor, the office, we announced that these were the 5 people we wanted, and the rest should come out and make use of the amnesty that is being offered by the Uganda government. So this is a way of showing that, okay, these are the ones we feel they are most responsible. You have to answer to justice, but at the same time, there are others, don't just stay in the bush, take advantage of the amnesty that is being offered by coming out. So yeah, I really think that it's mutually inclusive.
Well, thank you. That's a really helpful insight. And you already answered the next question I was going to ask, and that is, in the human rights, international human rights community, there's this tension, this dilemma about trying to conclude a conflict at the negotiating table, and you have perpetrators who are seeking immunity from prosecution so that they don't have to go in front of the ICC. And just a very simple, brief description of that angle is, well, if you can't use immunity from prosecution as a bargaining chip, there's no incentive to sit down and negotiate a peace. On the other hand, as you've already eloquently pointed out, your role of the ICC is to prosecute those who are most responsible for the crimes, and it acts, as we all know, that conflict thrives in impunity, and so if you eliminate impunity, then you have the additional incentive not to commit crimes, knowing that you might be called in front of the International Criminal Court. Is there any final insight that you would like to share on that dilemma that that you haven't already mentioned?
Well, yes, I think I've already mentioned it, but even when you come across many of our situations, the situations that the ICC was dealing with when I was still there. There was indeed the issue of let's put justice aside and let us try to see how we can just bring back peace. But what experience has shown, and I'm sure, you know, with knowing about the history of human rights and conflicts and the cycle of violence that can happen in many situations, we see it unfolding before our eyes, is usually because there has been no justice. No justice. I do not take that statement lightly, that there can be no peace without justice. You know, there should be justice, and people should feel that justice has been done in their stead, as a result of which perhaps also those who are held to be the perpetrators would learn from the fact that, or others who were the onlookers will know that they cannot do it without being held responsible for that. It really helps. It helps, and we should not just let those who perpetrate these crimes to go free, because yeah, we want to have peace, because peace will never come. It will, the conflict will rear its ugly head again sometime down the line, and there would just be this vicious cycle of violence all the time.
Thank you, Prosecutor. That's a very helpful insight. Before I ask my final question, I'm wondering if you might share with our viewers the screen behind you and explain what that is, and that will lead to my final question.
This screen is one of the religious historic sites in Timbuktu. This was my last visit, actually, before I left office. I have brought a case in the situation in Mali. After investigations, Mali, in fact, the referral was made to me by the government of Mali. And following investigations, we were able to find that there was just rampant destruction of cultural heritage. And we were able to bring our first case in the situation in Mali, in which Al-Mahdi was charged for the destruction of these properties. As you know, this is under the Rome Statute. This is a crime under the Rome Statute. And again, it was something that I wanted to highlight, that we could not just allow, and you see that this is rampant in most of the conflicts that have happened in the 20s lately. I'm not talking about what happened before, but this became the norm of destroying very, very important buildings that are dedicated to religion or to education. It became, again, once again, the norm. And I thought that these are buildings that represent an identity of a people. No, these are buildings that you could not just destroy at will. So I brought this case, the Al-Mahdi case, and Al-Mahdi was eventually convicted, and he's serving sentence. He was found guilty, convicted, and he's serving sentence as a result of this case. Again, like I did in the Lubanga case, I wanted to highlight the importance to protect the cultural heritage. It's not just for the particular situation or the region. In fact, it's for the whole world. These are properties that have become preserved by UNESCO as World Heritage Sites, and their destruction is definitely very, very serious crimes. So I was able to get, that was one of the also big successes of the Office of the Prosecutor.
Yeah. Well, thank you. Thank you for sharing that. And that was really my question. You know, why is it significant that that the ICC would look at cultural and religious heritage as something worth protecting? And I think you've answered that very well. So thank you for leaving that legacy at the ICC, that when you look at genocide and some of these other crimes, it's about eliminating identity. And I think that you see these cultural and religious heritage sites as, important as one's identity. So thank you again, Prosecutor Bensouda. I appreciate you taking the time to share your insights on those questions. And I'd now like to pass it over to Maria Cortese. Maria is co-chair of the Women's Bar Association of the State of New York, International Women's Rights Committee. In previous years, she served as the president of the Women's Bar Association of the State of New York. Maria, a prosecutor with the Office of the Bronx DA, has assumed many leadership roles in that office and serves on many committees in New York State, such as the New York State Judicial Committee on Women in the Courts and the New York State Justice Task Force on Wrongful Convictions. In 2011, the ICC Office of the Prosecutor invited Maria to present as a guest lecturer as a part of a week-long series, and she presented on the panel titled Comprehensive Modalities for Addressing Victims' Needs under the Rome Statute System. So Maria, it's all yours.
Thank you, Michael. Good afternoon or good evening, Prosecutor Bensouda. I want to also express my gratitude for giving us your time to give us insights and sharing your experiences in your pursuit of justice and peace one day. You've repeatedly emphasized the importance of states' cooperation in all phases. During the preliminary examination phase, when you're looking into a situation to determine whether a state is either willing or has the capacity to assume the primary responsibility to investigate and prosecute those responsible for serious crimes, what are some of the practical challenges that the office has had to face? Because now everyone is on notice that there is an investigation that might ensue. And when I talk about practical, I'm talking about, witness protection or perhaps evidence collection or destruction or things in that regard.
From the time that the ICC decides to intervene, like for instance, maybe there is a referral from a particular country or that country makes a declaration when it is not a state party and accepts ICC jurisdiction. Once a decision is made that we open preliminary examination to determine this, of course, it needs, we need a lot of cooperation even at that stage, because we need to collect the information. Of course, we don't have to go out ourselves all the time during the preliminary examination phase to get the information, because we can also get it through people sending in information, making Article 15 communications and all that. But even at that time, when it is important that we have cooperation to be able to collect the information we need to make a decision, whether to open investigations or not to open investigations. But once investigations start, one of the first things that we normally do was to be able to go to the situation concerned and engage with the relevant authorities on the ground who would assist, because here we are not asking them to investigate. I've always said that the investigations have to be independently done. But notwithstanding, we need logistical arrangements to be able to investigate, like we need safe houses. We need to ensure that we have a particular location in which we can meet with witnesses and it is secure, and that we do not expose the witnesses who are giving us information or even informants. We also need to ensure that there is security for those who speak with us. And at some point, we have to get the registry involved to be able to assist with some of those logistics, but especially with the issue of protection of witnesses. Because as you know, in the Rome statutes, once you contact a person who could be a witness, but once you have made that contact, you have an obligation to protect them. You have an obligation, especially now when they become witnesses for the prosecution or even for the defense. There is that obligation on the prosecutor, on the registrar, on the judges, everyone, to ensure that these witnesses are given the full protection that they deserve to be able to give the evidence that they should. So cooperation is indeed very, very important at that time for us. And then we need to discuss the issues of privileges and immunities, which some states have signed, some states have not yet signed. But it's important to make sure that the staff of the ICC also, what their privileges and immunities are with respect to that particular country. And sometimes you may even need to go to neighboring countries to ask for help. For instance, a situation happens in which you find people running out of the country to seek shelter in another country. You probably want to go and speak with those people about the conflict. So you also need to perhaps approach those countries to help in accessing the witnesses. So cooperation is very important. It's really very important and again, I emphasize that it's an obligation. Once you are a state party to the Rome Statute, what you're directly saying is that I will cooperate with the ICC when they make their decisions, when they issue their warrants, and when they seek cooperation to do their investigations. I am going to cooperate and I'm going to assist. So this, as you know, Maria, the ICC was set up without a police, without army, without enforcement agencies. So the enforcement agents in each country, the state parties of the Rome Statute are supposed to be that of the ICC as well. And this is how important cooperation is within the framework of the Rome Statute.
Thank you. So in this regard, does it become more difficult to navigate once you reach the investigation stage and it is determined that the state is in fact not willing to assume primary responsibility or lacks the capacity to do so? And aren't the stakes even higher?
Yes, indeed, the stakes are even higher. In some situations, there's just, as I mentioned before, a complete shutdown that we're not going to cooperate. And at the same time, they are not investigating or prosecuting, but they are also not going to cooperate with the ICC. So this becomes a problem. And again, we don't have to throw our hands in the air and say, oh, okay, we cannot do anything. We have to find ways. And we also have to think out of the box to say where we can go, who we can talk to, which places we can go to be able to gather the evidence. And this has happened not once, not twice in the various situations. The stakes are even higher, you are right.
So for instance, let's talk again briefly about Darfur. I mean, there was a point of complete shutdown there, and the Office of the Prosecutor had to find new strategies of trying to obtain evidence without going to Darfur. Can you share how your office did it?
Well, I probably will not be able to share everything.
Okay,
but
understood.
Because of course, confidentiality of investigations and strategies and all that. But of course, we had to look for where we could get the information. And maybe the way I can put it is that the information could also be found outside of Darfur. So in the end, if I remember, we ended up visiting at least over 20 countries.
Wow.
To interview witnesses, and not all necessarily within the African continent. They were also to be found elsewhere. And we had to, be looking very closely, getting information, trying to contact, and then deploying and speaking to witnesses, and just trying to get the evidence. Because not only were the displaced camps, but there were also people who ran out of Sudan and were refugees outside. So it was possible to also get the information from people like that.
So you must have expended immense resources, both financially and
indeed
to do something like that. Over how many years? I mean, it's a huge undertaking.
Yes,
that you took and did successfully. We're very proud of that. Okay, so next I'd like to talk a little bit about, we've spoken about, witnesses and the importance and how the Rome Statute actually, requires us to protect witnesses who cooperate with us. And the immeasurable trauma experienced by victims of genocide, war crimes, crimes against humanity, and aggression was explicitly addressed in the Rome Statute, which mandates protective measures and security arrangements, excuse me, counseling and other appropriate assistance for witnesses, victims who appear before the court, and others who are at risk on account of testimony given by such witnesses. On this issue, the statute also states that there must be a staff with expertise in trauma, including trauma related to crimes of sexual violence. And your office has, in fact, psychologists in place for this express purpose. You've spoken about supporting young victims in the creation of the Children's Unit to help children cope with the process, the very difficult process. Can you tell us when interventions begin, how victims, children, and adults are supported practically in this regard? How is it working? Can you give us examples?
Well, you see, of course, there is the victims and the Gender and Children's Unit with psychosocial experts in the office, but also the issue of witnesses and their welfare really is a matter for the registry more than the registrar, more than the office of the prosecutor. So there is, first of all, there is the Office of the Public Counsel for Victims. There is also the VPRS, which is also for victim reparation and which is within the registry, and they are also able to do their own work directly with the victims concerned. And I believe that there is also the fact that all this there has to be some coordination, because at the end of the day, what we want to do is not to re-traumatize these victims. We cannot do that. So as soon as we get into contact with them, and especially the Office of the Prosecutor, because we are the ones who make the initial contacts, if we feel that this is possibly someone who we will go much further with, we make an assessment of that particular, it is just an example of that particular person's situation, and also perhaps the likelihood that he may be subjected, there may be protection issues arising. Then we make a referral, what we call a referral to the registry for them to make, because there, of course, they have more expertise on it, and they are also able to contact these witnesses and make further assessment and see what is the best way of going forward of dealing with this particular witness. It also, for instance, in court as well, there are some measures that are taken. If you feel that exposing the witness would, of course, bring protection issues, there are voice distortions, there are face distortions, there are also perhaps even giving the evidence remotely. When it comes to perhaps a witness needing special protection, there is always someone who is able to sit with the witnesses to assist the witness when the evidence is being given, even when they're speaking to investigators. So there are various ways, but first and foremost, what we were concerned about is that this witness, if there is any protection issues, that fully this will be granted to them, because it is their right. And also the fact that we cannot do anything that will re-traumatize them, because already they've gone through a lot. And our processes should not put them in even more trauma than they had.
Agreed, absolutely. Well, in 2010, there was a Kampala review conference during which time states, members of the court, victims, and their representatives did a stock taking of how the court fared with respect to the treatment and support of victims before the court. What was the assessment then, and what would you say that things have improved now?
Well, I of course, there were, what I say is there is always room for improvement, always. And I had always said to my office, and I think this is something we publicly live by, to say that the office was a continuously learning institute, that we needed to continue always and give our best. And if that was not enough, to look for the best and do that. So where there were areas that were identified at the time, I cannot readily remember it all, but what I can remember is that we took deliberate steps to work on that and to ensure that we do things better. Of course, it was at a time when we also were able to learn, at least on a first case that had come up, and also learned lessons from that and be able to practically apply that, both during the time of investigations, but also during prosecutions and later on, even during reparations.
Would you say that technology played a large part in this, the development of new technologies?
Yes, indeed, technology has played a big role. In fact, when I saw that there is so much that we could do with respect to the advancement of technology, by even for witness protection, but also for saving costs, I sort of raised the level of the forensic unit into a section. And I ensured that I had more resources added to that section, such that we were able to, for instance, when we were presenting the evidence in one of the DRC cases, we did not have to bring in some of the witnesses to show us where they started from, where the two opposing armies or militia were fighting, which hill they came from. We were able to do a 360. And this is what we presented to the judges. And it made it look as if they were actually in Ituri and observing there what was going on. So these were some of the developments, technology, as you're saying. But even in the Al-Mahdi case, this is also another way in which we exploited technology a lot. So in effect, one of the strategies that in my strategic plan, one of the strategies that I had was to, of course, we have used alternative ways of presenting evidence or collecting evidence, but in fact, it was more enhanced I think it was the second strategic plan, or even the first strategic plan that I had after I took over as prosecutor. And of course, this would help to ensure that when witnesses are interfered with and they could not, they actually withdrew. We have had it in some of our cases, they withdrew. Then we really needed to start looking at other ways in which less and less you would use persons as witnesses.
Excellent. So sometimes overlooked, secondary traumatic stress, also known as vicarious trauma or compassion fatigue, is caused by being indirectly exposed to someone else's trauma for prolonged periods of time. It occurs when doctors, lawyers, law enforcement, and other professions are affected by those they are serving. This is also very true for prosecutors, and it is believed that the most effective prosecutors are those who are deeply connected with the people and convey the fact to the fact finders the essence of human tragedy that suffered by the victims from whom they advocate. As prosecutors, it is a delicate balance we are constantly trying to obtain. How are prosecutors in your office charged with investigating genocide, war crimes, crimes against humanity, and aggression, and exposed to incomprehensible human tragedy supported? And how do you personally handle this?
At a very early stage in my career at the ICC, we realized that secondary trauma could be something very, very serious. And you even had people with burnout because of just the horrible things that we had to investigate and to deal with, sometimes on a day-to-day basis. And I even recall in the first case, which is the Uganda case, in which we had transcripts and transcribers of the, the different communications that was going on between the commanders of the Lord's Resistance Army. And we had to have people who would listen to them all the time and transcribe them. This is really, really something very, very difficult. And obviously we did have some who got trauma out of that. Perhaps this is a good example that I can give you, but also the fact that some of these investigators listening to witnesses day in, day out, telling them about the ordeals that they have lived through and the sufferings and the horrific things that has been done to them or to their relatives or to their neighbors. It's also not easy for the investigators themselves. So we have had, in fact, concretely looked for experts in trauma who would, from time to time, we will organize training in the office, who would from time to time be able to sit with them, organize a group training in which they can actually talk about these things and receive guidance from these experts to help them through these very difficult times that they're living with.
And how did you handle this yourself?
Yes, it's also not been easy, especially if you care so deeply about what is happening to them, and also the fact that you want to do something about it. So it's something that you live, really, you kind of live it. Of course, I'm not saying in a way live in the sense that it cannot be worse than what the victims have lived through. It cannot be, but it is also not easy. But I was always motivated by the fact that I needed to give my best for the victims. I needed to be there for them. I actually thought that if I was more focused on myself and the trauma, perhaps I would not be able to be there for the victims as I should. So this maybe is one of those things that has really kept me going, that I wanted to see positive results for the office, but also especially very good results for the victims. So I kind of just shoved it at the back and carried on. But I must say also that occasionally I would also join these trainings and would just try to see how to cope with it.
I'm sure there are times that you feel, I don't know if vindicated is the right word, but you feel that it was all worth it. When you, in Darfur, after there was actually the surrender and everything, can you describe what happened when you went back to Darfur?
This was really, I think this was one of the very good moments that I have lived as prosecutor of the ICC, because this was a time when, before then, everybody has lost hope in Darfur. We were struggling. We were having difficulties with the Committee on Budget and Finance to justify why we had to continue Darfur. And all of a sudden, there were changes in Sudan. Bashir was arrested, no longer president. He was detained, actually. And I immediately jumped on the opportunity and reached out to the authorities who were in place. And the next thing I knew was that I was in Sudan. So I always say that when I was received at the airport by some of the relevant ministries, and when I heard "Welcome to Sudan," I could hardly believe my ears that this was actually happening. That just shows you the frustration that we have had for so many years. And in the end, even thinking that this was not going to be possible, yet at the same time saying that we have to continue with it. So when on the second time, I went to Darfur, really for the first time. I was in my second visit to Sudan was to go to Darfur and to meet with the victims, meet with the affected communities, hear firsthand from them about their plight, and also to listen to what they also perhaps were waiting all these years to be able to share. This was really a moment. It was a moment. And I felt, I wouldn't say vindicated, but I could just see how justice is so important for them, despite all that they have been living through. And you could see the conditions. It was terrible. But they all spoke about justice. They all spoke about justice. And this was a great sense of courage for me, encouragement for me.
And who did you meet with? Who did you find when you got there? Like, was there?
Oh, I found the whole community from the different leaders of the communities down to even the little children. It was a huge crowd, over 100,000 people were there or more. And they were chanting, you know, welcome, welcome ICC. It was a moment really that deeply touched me. And the fact that all this while and everything that they have gone through, they could have been discouraged, but they still wanted the ICCs to be there, and they still wanted justice. So I really met with, I went to different camps and met with different, those who are the leaders of the camp, as well as the communities that they have set up there. And I had meetings and moved from camp to another. It took me, I think, 3 days or so to visit from one camp to another, and to, yes, just to meet with the communities. This was really something yeah, it was a big moment for me, big moment.
So perseverance and justice prevailed.
Yes.
So now, what is your vision for your next role? I mean, what do you see yourself? We're all watching you. What is your vision? What do you plan? What are your plans? What are you doing?
Well, at the moment, I perhaps you have not seen it, but I was appointed by the president of the Human Rights Council to lead the Commission of High Legal Experts on Ethiopia, Tigray. In fact, I am right now on my way to Geneva to have my first meetings, and also to plan with my co-commissioners how we are going to work on this situation. It is also a very serious situation, as you know, from 2020 until now. It has been going on. There has been a lot of unfortunate loss of life. And this is a matter that the chairperson, the president of the Human Rights Council wants me to stare. So this is a role that I of course, is very similar to what I was doing. But as I always do, I have pledged to do it with complete independence and impartiality, and but also without fear or favor.
Well, they're very, very fortunate to have you on their team.
Thank you. Thank you.
I think now I'm turning to Faye, who needs no more introduction.
Yes, thank you so much. I mean, I am so thrilled to hear, you know, you've given us so much information, Prosecutor Bensouda, and we are so grateful, and I love ending on that wonderful note, because justice will prevail, and we are so grateful to the example that under your leadership the office has shown, and on behalf of victims. And now I would like to just say that we are going to view some highlights of Prosecutor Bensouda, accompanied by music from Carlo Lad. Thank you everyone for such a wonderful program. Thank you all of our participants. Special thanks to Prosecutor Fatou Bensouda for your indomitable spirit, for the tremendous work that you have done on behalf of humanity and on behalf of victims. We thank you, and we know that in your next role you will be as successful and as supportive as you were in the previous. So I thank you. Thank you for all of our co-sponsors. Have a wonderful evening, everyone. Good night.
Thank you. Thank you very much. Thank you.
Thank you. Thank you.